The 1967 Arizona Consumer Fraud Protection Act, CFPA, was created to protect the public from deceptive, unfair, or fraudulent practices in all types of commerce, including real estate. Enacted during a national movement for consumer rights, the law ensures that Arizona residents can make informed decisions without being misled by false advertising, concealment, or manipulation. It represents one of the most important consumer protection measures in Arizona history, designed to maintain fairness, honesty, and transparency in the marketplace. The primary purpose of the CFPA, found in ARS Section 44-1521 through Section 44-1534, is to prohibit deceptive conduct in connection with the sale or advertisement of merchandise, a term that includes real property. Under ARS Section 44-1522A, it is unlawful for any person to use deception, false promises, misrepresentation, or concealment of material facts with the intent that others rely on such conduct. Importantly, the law does not require proof of financial loss or intent to deceive. It is enough that the conduct was misleading or capable of deceiving a reasonable consumer. The core elements of the Act include prohibition, enforcement, restitution, and prevention. It bans deceptive acts, grants the Arizona Attorney General authority to investigate and prosecute violations, allows courts to order restitution for victims, and emphasizes education to prevent future fraud. These components work together to protect consumers before, during, and after a fraudulent act occurs. The Act is both preventive and corrective, reflecting the state's commitment to fairness in all business dealings. The CFPA applies directly to real estate transactions because real property is considered merchandise under the statute. This means real estate licensees, sellers, developers, and even unlicensed individuals involved in the marketing or sale of property must comply with the law. Violations often arise from misleading advertisements, false representations about property conditions, or omissions of material facts. For example, describing a property as zoned for commercial use when it is zoned residential, or failing to disclose a known foundation problem would both be violations. The Act also prohibits bait and switch tactics, where an agent advertises one property or price to attract buyers but pressures them to buy another. Misrepresentation of material facts is one of the most common forms of consumer fraud in real estate. A material fact is any piece of information that a reasonable buyer or seller would consider important in making a decision. Misrepresentation may occur through an outright false statement or through omission, failing to disclose something significant. For example, concealing termite damage, exaggerating square footage, or omitting homeowners' association fees all qualify as misrepresentations under ARS Section 44-1522. Arizona courts, including in Dunlap v. Jimmy GMC of Tucson, Incorporated 1984, have ruled that concealing material facts is just as fraudulent as making false statements. Common violations of the CFPA include deceptive advertising, concealment of property defects, false promises about investment returns or amenities, and failure to disclose material facts. Even acts that do not result in actual harm can be punished if they have the potential to mislead. For instance, using altered photos in listings, advertising new construction that is several years old, or misrepresenting a property's income potential are all prohibited. Both the CFPA and ARS Section 32-2-153A3 under real estate law hold licensees accountable for honesty and fair dealing. The Arizona Attorney General is the primary enforcer of the CFPA. Under ARS Section 44-1524, the Attorney General has broad authority to investigate complaints, issue subpoenas, compel witnesses, and bring civil or criminal actions against violators. The office can seek injunctions to stop deceptive conduct, obtain restitution for victims, and impose civil penalties of up to $10,000 per violation under ARS Section 44-1531A. In cases involving real estate professionals, the Attorney General often works alongside the Arizona Department of Real Estate, ADRE, which can impose additional disciplinary actions such as license suspension or revocation. The Attorney General also plays an educational role by issuing consumer alerts to help the public identify and avoid scams. Overall, the CFPA ensures that consumers are treated honestly and that real estate professionals uphold the integrity of their industry. It reinforces that truthfulness, disclosure, and ethical behavior are not just professional obligations, they are legal requirements. Key points to remember for testing. The CFPA was enacted in 1967 to protect consumers from deceptive, fraudulent, or unfair business practices. The law is found in ARS Section 44-152, 1 through Section 44-1534, and applies to all merchandise, including real property. A violation occurs when someone uses deception, misrepresentation, or concealment of material facts, even if no one is financially harmed. Common violations in real estate include false advertising, concealment of property defects, and misleading statements about zoning, amenities, or investment potential. Misrepresentation can occur through both false statements and omissions. The key factor is whether the fact is material to the transaction. The Arizona Attorney General enforces the act through investigations, injunctions, restitution orders, and civil penalties of up to $10,000 per violation. The Attorney General collaborates with the ADRE, which disciplines licensees who violate the act or engage in dishonest conduct. Honesty, transparency, and full disclosure are essential to compliance with both the CFPA and Arizona's real estate laws. By understanding the history, intent, and enforcement of the 1967 Arizona Consumer Fraud Protection Act, you can better recognize what constitutes deceptive conduct, how it applies to real estate, and the serious consequences of violating it. For your exam, focus on the statute's purpose, the role of the Attorney General, and how misrepresentation and non-disclosure fit into the definition of consumer fraud in real estate.